Hello, everybody. Tansei. My name is Brittany Matthews, and I'm really thrilled to welcome you to the Jordan's Principle webinar, Knowing Your Rights Under Jordan's Principle. It's hosted by the Caring Society, and we're joined by a couple amazing partners as well. And so we're going to start the webinar now, and the folks can join in as needed. Um, so today I'm speaking to you today from unceded, unsurrendered Algonquin territory, currently known as Ottawa, Ontario. And I'm really pleased to be here to speak about this really important subject. We're going to have four presentations, followed by a Q&A session that will start around 2:30 to 2:40 p.m. Eastern Standard Time. We would ask that folks not record this webinar, be it through AI or other means. The webinar will be available publicly on the Caring Society's webpage and YouTube page, and that will be available in the next day or two. You're welcome, and we would invite you to put your questions in the Q&A function. When they are answered, you will be able to see them. Everybody will be able to see them. We may not be able to get to every single question. And we would also ask that folks be patient with us as we go through the questions. My wonderful colleague Stephanie is going to lead answering these questions, and the rest of us will help out as well. And some of them we'll put to the panelists. Um, we also won't be able to address any personal cases. And then also, just as a quick note, this webinar is to provide general information and is not legal advice. You may wish to seek legal counsel for your specific situation as well. So without further ado, I am really honored to introduce Dr. Cindy Blackstock, the Executive Director of the Caring Society. Cindy is a member of the Gitxsan First Nation, and she's also a professor at McGill University School of Social Work. She has over 30 years of experience working in child welfare and Indigenous rights, and is a well-published author as well. She was most recently named the recipient of the 2023 World Children's Prize for the Rights of the Child, an award adjudicated by millions of children worldwide, and referred to as the Children's Nobel Prize. And you will often see her in the accompaniment of Spirit Bear, who's actually joining my colleague Jess today. So without further ado, I welcome Dr. Cindy Blackstock. Thank you.
Well, thank you, Brittany. And I first of all want to say thank you to everyone who has joined to really honor the 20th anniversary of Jordan's Principle. Jordan's Principle is named after Jordan River Anderson from Norway House Cree Nation. And we need to always remember that Jordan was in a situation where his rights were egregiously violated by both the Canadian and Manitoba governments. And that gift from the family of Jordan's Principle was to ensure that the similar situations never happen to any other child. Jordan's Principle's a legal obligation on behalf of the Government of Canada. It is not a program, it is not an option, it is not a recommendation. There are legal orders, and Jess Raby from our Caring Society team will be taking you through some of those legal orders that have been set by the tribunal, and that Canada, like everyone else in the country, has to follow the law. I would say that there's a lot of conversation more recently coming from the federal government about bringing Jordan's Principle back to its original meaning. I'm not sure what they mean by that, but I am sure that it doesn't mean introducing jurisdictional disputes between provinces and the federal government and therefore denying children's services. And it does not mean allowing denying an expense within the federal government because some other program in the federal government or some other federal department is supposed to pick it up. Both of those things were in play when poor Jordan suffered for 2.5 years in that hospital. It was exactly that kind of thinking that led to it. And Jordan's principle is to ensure that children get the health education and social supports they need when they need them, free of any jurisdictional wrangling. For those of you who were part of working on Jordan's principle back in the early years, you'll remember in the Wande reports that the most frequent type of jurisdictional dispute was actually within the federal government itself. The feds would say, well, you have to go check out First Nations Inuit Health Branch, or you've got to, the child and care people will look after it, or somebody else will look after it. And this type of buck passing, it was really one of the cornerstones of the rights violations that Jordan experienced. I also want to just recognize that we're seeing non-compliance by the government of Canada and therefore children in crisis at levels I personally have never seen before. And many of you are looking for answers as to how you ensure that children's legal rights are recognized. And what that really means on the ground is that children's lives are saved. Children are able to go to school and even if they learn in different ways, be set up for success. And that nobody, no adults are trying to pass the buck or trying to obfuscate their obligations towards a child, that the children really are at the center of it. That's what Jordan's principle really should be doing, but we're seeing broad-based non-compliance, and that's why this webinar is so important, because we at the Caring Society, frankly, can't keep up with the number of needs that are out there right now, and we know you have questions too about what can you do? What are those legal rights? How can you make sure that you're doing your due diligence to make sure that the federal government observes it? And what if they don't do it, even though that you've got that professional letter that documents the child's needs, the guardian has consented, and they're still saying no, or they're wagging the puck? That's really the conversation we want to have today. We're not going to be able to provide you with all the answers to all of your questions, as Brittany said. But we are going to do our best to begin the conversation of how do we all work together, including with the federal government, to ensure that all First Nations children are able to experience the gift of Jordan's principle, and that we treat Jordan's principle with the respect and dignity and sacredness that it enjoys. So I'm going to just pass it over to Jessie, who's going to take us through the long list of orders that set out the various rights that all First Nations children on and off reserve who are recognized by their nations enjoy.
Thank you so much, Cindy, for that welcome introduction to this webinar. And as Cindy said, we're going to ask our wonderful colleague, Jess Raby, to present next. And as a quick introduction, Jess is from the traditional territory of the neutral Anishinaabe and Haudenosaunee peoples, currently known as Brantford, Ontario. She has a Bachelor's of Arts degree in Human Rights and Law at the Carleton University, and she then went abroad to the UK to complete a Master's of Law in International Human Rights at the University of Sussex. And she's very happy and thrilled to work at the Caring Society, and she does a lot, not in addition to working on Jordan's principle and human rights policy, she also leads a tremendous amount of our public education initiatives. So take it away. Thank you, Jess.
Yeah, good afternoon. Good morning to those who are joining in other time zones. Thank you both to Brittany and Cindy for such a warm introduction and for really setting the stage for our conversation this morning. I'm also joined by Spirit Bear, as Cindy mentioned, and I'm going to walk you through a few of your rights under Jordan's principle, really being cognizant of some of the things that you may be confronted by, some of the information that you may be receiving from ISK, and also contrasting that with what the legal orders say from the tribunal. As you may know, the tribunal orders are the bare minimum for which ISK has to implement Jordan's principle. So those are our guiding posts when looking at Canada's compliance or non-compliance. So but just very briefly, in terms of Canada's non-compliance on Jordan's Principle, we're at 30 plus procedural and non-compliance orders at this point. The latest one being filed by the Caring Society in December of 2023. Some of the key issues that we were seeing arise during that year were issues of, lack of timely and compassionate responses, particularly regarding urgent cases, delayed responses in terms of requests, which has amounted to a backlog of 135,000 requests as of February of this year. Additionally, many other issues regarding families and service providers and guardians having issues contacting the 24-hour call center or the regional phone lines, which is a problem when families especially need to place an urgent request, amongst various other things. And so what ended up happening is that First Nations, for example, have been forced into providing bridge funding for their children, which means that they are not being reimbursed timely by the government. And also service coordinators are really taking on the brunt of the non-compliance on the ground level with regards to timelines and non-responsiveness and the backlog especially. And so at the end of the day, given that this case started in 2007, we can see that despite knowing better, Canada is choosing not to do better. And so at the beginning of this year, the tribunal issued orders with their full reasons on the non-compliance motion that was filed back in 2023. And I'll ask my colleagues to pop in an information sheet for your review, but also just at the high level, these are some of the things that you might be interested to know that came from those orders. So first and foremost, the backlogs have to be addressed immediately. The tribunal said that Canada has to address the backlogs. Requests that require reimbursement or proper funding have to be done in a way that does not inflict any hardship to those who are seeking the reimbursement. So this means families who have gone into debt, First Nations providing that bridge funding without reimbursement. Urgent requests, in terms of the definition, Canada put forward an amendment to change the definition of an urgent request, to which the tribunal did not issue any orders to change that definition. Foremost, Canada has to close the gaps and coordinate its federal programs, which it was ordered to do back in 2016, actually. So really problematic that a similar order has been issued almost 10 years later. And it has not provided any evidence, Canada has not provided any evidence that it has been plugging the holes in federally funded programs, and it has not put forward any evidence to suggest that they are coordinating those programs. In 2017, CHRT 35, the tribunal has said that it is the government of first contact that is responsible for determining that request and providing funding. So the government cannot divert families to seek help through other programs. It has to deal with it and deal with the payment behind the scenes with the department or the government that needs to deal with it. Additionally, an independent national complaints mechanism is required, so an outlet for families to voice their concerns. And Canada cannot refer families, service providers, anybody placing a request to a First Nation if they are transferring their legal obligations and setting First Nations up to fail. So just as an update for you, parties are still in mediation. Mediation began at the beginning of the year and is ongoing. So in terms of what you may be seeing, it's no secret that Canada released, or ISC released, an operational bulletin on February 10th in 2025. Some of the key issues that the Caring Society takes with the bulletin is how it applies to urgent requests. We now know that they are applying the operational bulletin retroactively to the backlog, which is very problematic. And ISC is, in other ways, asking families to prove that there is no existing gap in other services, which it is our opinion that that is not on families to prove. And then also narrowing the scope of products, services, and supports eligible through Jordan's Principle, which we'll get to in a minute. There was no consultation with the Caring Society nor with other parties who, like I said, are in active mediation and were in active mediation at the time the bulletin was posted. And so the Caring Society has asked that Canada retract the bulletin, to which they have not done so yet. Additionally, you may have come across this on IS website. So these are a list of non-eligible services, supports, and products funded under Jordan's Principle. I'd like to take the opportunity to clarify that these supports are eligible through Jordan's Principle, really highlighting the insertion of unless it is linked to a specific health, social, educational need of a child or accompanied by a letter of support from a medical professional. This is essentially a loophole. So I just want to take the opportunity to clear the air that you can still place a request for these services. They are eligible through Jordan's Principle. Also, in terms of what supports, products, and services are eligible through Jordan's Principle, this is what the list used to look like on their website. So as you can see, there's many bullet points with many services that you can place a request for through Jordan's Principle. To contrast that with what it looks like today, there are obviously a lot less bullet points. However, this does not mean that those services that were listed previously are not eligible through Jordan's Principle. You'll also note that they've added the terminology of on reserve and attached that to the end of certain supports. To clarify, the tribunal has made orders back in 2017 to say that First Nations children who reside on or off reserve can access Jordan's Principle. It is not one or the other. This was later reaffirmed in 2020 when the tribunal said that non-status First Nations children who reside off reserve and are recognized by their First Nation can place a request through Jordan's Principle. So despite what it says on the website, whether you live on or off reserve, you can still place a request to Jordan's Principle if you are eligible to do so. In terms of the backlog, this data comes from the March 7th report that the tribunal was ordered to provide that Canada was ordered to provide to the tribunal and to parties. So we know the latest data is that the backlog sits at around 135,000 requests. And so in terms of what the tribunal has ordered for the backlog, first and foremost, that Canada has to tackle the backlog. And for all of you who maybe have a request sitting in the backlog, Canada has to triage the backlog. So in intake, they don't necessarily know whether the request is urgent or non-urgent. And so the tribunal has said that you have to look through those requests and ensure that any urgent cases are flagged and dealt with immediately. And also, for your knowledge, they have to communicate with all requesters and provide interim measures to ensure that further harm is not incurred. So that communication has to be there, and that is tribunal ordered. And so in terms of determination timelines, the most recent report that we have is from March of this year. And so for urgent individual requests that have to be determined within 12 hours, Canada is meeting that around 16% of the time. In terms of urgent group requests, so 48 hours for determination, Canada is meeting that 0% of the time. And as you can imagine, what incurs from this is an increasing severity of harm for kids and for families. And so what does the tribunal say about this? Well, again, back in 2017, this is when the timelines were created. And so as it stands today, urgent individual requests have to be determined within 12 hours, non-urgent individual requests within 48 hours, and the same 48 hours for urgent group requests, and 1 week a determination for non-urgent group requests. And again, in 2025, the beginning of this year, the tribunal has said that they are not going to change the timelines for urgent services at this point. And Canada's proposal of introducing an unreasonable delay is not in line with the best interests of the child and is too vague. So as it stands, these timelines, despite maybe not being complied with, are still intact. What we know about urgent cases, the tribunal did issue an interim list of what is considered urgent. So that includes life-threatening cases, cases involving end-of-life or palliative care, risk of suicide, risk of physical safety, a child with no food or basic necessities, risk of a child entering the child welfare system, caregivers and children fleeing from domestic violence, and certain time-sensitive cases. This list is not exhaustive, so there may be exceptions, such as bereavement, for example. The tribunal has said that bereavement and the passing of a close family member may be considered urgent, while other times may be considered time-sensitive. So if your request falls into one of these, or if your request has been, waiting for a determination for so long, you do have the option to escalate that to urgent by contacting either the 24-hour call center or your regional Jordan's Principal office. In terms of supporting documentation, as has always been the case, documentation requires parent or guardian consent and one referral from a professional, so related to their scope of practice. For example, if somebody's requesting a medical device, their doctor can provide that professional letter. And then for cultural, language, or wellness requests, an elder or knowledge keeper can provide that letter of support. In the cases of urgent requests, documentation can follow once the child's immediate needs are met. Any sort of detailed assessments or lengthy information, invasive information that ISC asks for is not necessarily needed to determine a request. Should more information be required, they can reach out to that recommending professional, so whoever wrote the letter, and ask for that information. It should not be on the family to have to answer for those questions, and this should not delay or disrupt the determination significantly or in any way. The tribunal has said in their latest orders that supporting documentation should be kept to minimal. So again, those detailed breakdowns, cost assessments, diagnosis, anything like that is not necessarily needed. The bare minimum is that parent or guardian consent and the letter from the professional or the elder and knowledge keeper. In terms of substantive equality, this is an example of a denial rationale that we've been seeing quite frequently. This is not an isolated incident, rather it's become quite common, and it's a redefinition of what substantive equality is and how they're applying it to determining a request. As a reminder, when determining a request, ISC should actually be considering substantive equality, culturally appropriate service provision, the child's needs, best interests, and distinct community circumstances. So when we say this normative standard, we mean the frequency, the duration, the type of product or service and support given to other children as a matter of course. That is the bare minimum, and that is what the tribunal has said. So in fact, when considering a request, they have to apply a substantive equality lens, meaning that they have to account for distinct circumstances, historical discrimination. For example, if a child places a request and there's a remoteness aspect to it, they have to take that into account when determining the request. And then, of course, earlier this year, it was reaffirmed in the tribunal's orders. And actually, importantly, the tribunal has said that substantive equality is a means to break down accessibility barriers and remove burdens on families and those placing requests to having to prove that they meet a substantive equality test. So it is not on families necessarily to prove that substantive equality applies. It's always been the Caring Society's position that it is up to the department to prove that it does not apply. And so in terms of the allegations of misuse of Jordan's Principle, I really just want to reiterate that there has been no evidence put forward by the government to prove that this has happened. We are safe. It is safeguarded by the fact that, the professional letter and consent is needed to place a request. And in fact, we know that ISC has not always asked for a recommending a letter with a request. And the tribunal has affirmed that, Jordan's Principle is a human rights principle grounded in substantive equality. Really, really important to remember. And it does not mean that all Jordan's Principle requests will be approved. It is not open-ended, but it is there to meet the needs of any First Nations child when they need it. And to just end on a good note, it is important to remember that Jordan's Principle has been life-saving and life-changing for thousands of First Nations kids. But the key component here is that it has to be implemented properly and according to the tribunal's orders. And so that, with that said, you can seek more information at fnwitness.ca with all the latest updates and information. And I'll turn it over to Brittany to introduce the next speaker.
Thank you very much, Jess, for that wonderful presentation. And so next up, we have David Taylor. David is an Ottawa-based lawyer and the managing partner at Conway Litigation. He has, since 2014, served as pro bono legal counsel for the Caring Society, before the Canadian Human Rights Tribunal, helping to achieve equity for First Nations kids. So take it away there, David. Thank you very much.
Thanks, Brittany. So the piece that I've been asked to talk about a bit this morning is some of the existing measures for challenging decision making, where there are denials or limitations that are being imposed under Jordan's Principle. So I'll talk about kind of the general structure and then a couple of points that are happening right now that will answer, I think, some of the questions in the Q&A that are coming up. Well, they may not answer them, but they'll at least address kind of what's going on from my, admittedly limited vantage point within this whole system. So the first point is that there is an internal appeal system inside Indigenous Services Canada. This is a variation of something that was constructed back in, started back in 2018, 2019, work on developing it. Which is a committee of external professionals who review cases that are under appeal and provide their point of view to an ISK decision maker. Now, until November 2024, the ISK decision maker was the chief science officer at ISK, who's a doctor, and he essentially signed off on the recommendations that the external decision makers made. And the tribunal describes this process in their most recent decision from January, and that was based on affidavit material that Canada filed in March of 2024 in the proceedings that led to that decision. And the purpose of having the chief science officer be the one to sign off on the decisions was to have some independence from the operational staff who were running Jordan's Principle. Previously, it was the associate deputy minister for the department and a senior assistant deputy minister not affiliated with Jordan's Principle operations who were making the decisions without any outside input. And then this new system was put in place. Now that changed in November of 2024, and that now the senior assistant deputy minister responsible for Jordan's Principle has taken over that decision-making function. And I have seen in denial letters that I've seen more recently her essentially substituting her views for those of the external expert review committee. And so the basis for that hasn't become clear, at least to me, but that's the state of play, as it stands today. And so in terms of accessing that process, there's a 1-year time period, at least it was 1 year when we designed the process. I assume it still is. I haven't seen anything to the extent it's not. Within which folks have to put forward an appeal. An appeal can include new documents, can include, where if you've got a sense based on the denial letter that there's a lack of understanding of the situation. This appeal process is admittedly backed up right now. The information that we've had through the Jordan's Principle Operations Committee is there's a 700-ish case backlog at the appeal step, and my understanding is that there are presently 6 appeal decision makers, and from what I've seen, they sit in groups of 3 on appeals, and those are heard in writing. There's not an opportunity to make a direct presentation to the appeals secretariat or to the senior assistant deputy minister once she decides the case. So when that happens, there's another letter that comes out, another approval or denial letter, and in the event of a denial, there's a 30-day period to go to a place called the federal court. And so the federal court is independent of government. It's part of the judicial branch. It's a specialized court that is set up to deal with matters of federal jurisdiction. And in this case, to for lack of a better word, supervise the federal government's implementation of its programs. So it doesn't just deal with cases having to do with First Nations kids. It deals with everything falling under federal jurisdiction. So it can deal with, immigration cases, federal labor cases, intellectual property, all those kinds of things. There have not been many Jordan's Principle cases adjudicated by the federal court. I think we're up to 4 or 5 now, and that's really back since 2013 when we had the first case that was decided even before the tribunal orders. What that process looks like is, and it's really one that is best assisted with a lawyer, but self-represented individuals can also access the court. It's a challenge. There's quite a lot of legal concepts that go into administrative law. But a document called a notice of application has to be filed within the first 30 days, and the denial letters that I have seen do note the 30-day period, to go to federal court. And essentially the notice of application sets out, here's the situation that the child is facing, here is the decision that's made, here are the points of disagreement with the decision, and that starts the process. What's important to note about the federal court is that it's not really an appeal as you might think about it. It's not a chance to re-argue the decision because under Canadian administrative law, the courts give a bit of maneuvering room to the government in implementing their policies. And so what the court is looking for is 2 things. They're looking for unfairness. So did something in the process happen that was unfair? And the most frequent kind of unfairness I think we would see in Jordan's Principle cases would be there was a problem with the application that was never pointed out to the person who made the request. And so there was a case earlier this year called Chauffeur, where a family went to seek judicial review. There were the internal records that came out as part of that judicial review showed the decision makers saying, hey, there's something missing here. But the family was never told about that missing element or given a chance to correct it. And what the federal court found is that because the level of fairness that should apply in Jordan's Principle cases is quite high, that family should have received some kind of notice from Indigenous Services before there was a denial saying, we can't approve this based on what you've given us. We think we're missing something that looks like this. And so that's really, we will see how that's implemented. I have a case that I'm dealing with right now in which it wasn't. But that's the kind of fairness or unfairness, if you see it in the decision, in terms of saying I didn't really have a chance to speak to that, where there could be an opportunity in federal court to challenge that. The second thing that the federal court is looking for is something called unreasonableness. And so when you talk about what's unreasonable, it's a failure to follow the legal framework that surrounds the decision, making decisions that has nothing to do with the evidence that's before the decision maker, things that are really inconsistent in terms of the reasoning and logic. And so it's not necessarily that they got it wrong. It's just that there's a failure of justification in how the decision was carried out. And so in terms of the process, you have to identify, one of those 2 things, to really have a kind of a leg to stand on in going forward in federal court. Like, what do you think is the unfair component of it? What do you think is the unreasonable component of it? And then it starts a process that goes forward from there. So there's something called a certified tribunal record, which comes in 20 days after the judicial review is started. And so that's essentially the documents that the decision maker had, and there are internal notes that would become apparent at that point that the family would not have had access to, or the service provider would not have had access to before that point. And then there's a series of filings that go from there. So each side has a chance to put in any evidence. Each side has a chance to make written legal arguments. There could be cross-examinations of people who are putting evidence in, and then there's a hearing that happens at the end of the process. The fastest that this process can go generally is 6 months to get to a hearing is quite quick. In particularly urgent circumstances, the court may be able to accommodate a faster hearing. But it isn't a quick process. Unfortunately, in Canada, most of our court processes take some time. And so there's a certain degree of patience that's required to go through that. And obviously, access to justice is an overarching concern, but in particular here, there's serious considerations of access and cost that go along with that. Just to speak to a couple of the questions in the Q&A, I noted a question there around Section 15 of the Charter and Section 5 of the Human Rights Act being kind of advanced as reasons to say substantive equality doesn't apply. That's before the court right now in a case that was heard 2 weeks ago. And so there may be more guidance coming from the federal court, and what happens after that is another thing to see. And so when you're seeing those kinds of limitations, know that there may be guidance coming from the court in terms of whether ISK is being unreasonable in the way it's reading substantive equality and kind of narrowing what were otherwise clear orders from the tribunal. And that may be an element for advocacy for taking another look at cases to the extent that the federal court comes out with guidance to say, something's gone off the rails here in terms of how substantive equality is being looked at. But we don't know how that's going to turn out. There's a judge who's independent who's looking at it, and she'll make a decision on that case, and we'll see where it comes from there. Certainly that'll, I'm sure, be posted on the Caring Society's website when it finally does come out. So just in terms of that, after that, there's could be appeals by other sides, but that's really the kind of the crux of that process, and there could potentially be opportunities along the way to reach an agreement with the government's lawyers. I've had some success over the years in doing that, less lately, in terms of proceedings end and they don't have to go all the way to a hearing. But really that's kind of the ultimate chance for an outside look at this. And then of course there's the Human Rights Tribunal, which at this point is, as Jess described, is working through this mediation process following from the orders earlier this year. But that's essentially the period there. So the last two ideas I just want to put forward in terms of accountability mechanisms through the court system is one, there is something called a stay. It's difficult to get, but there are situations where the federal court could intervene to keep supports in place that the government is proposing to terminate. It's quite a difficult test to go through to get that relief, but it is out there, just in terms of legal information. And then the second piece is where there's a really long delay. There's also a procedure that's called a mandamus. Mandamus is an old Latin word, which essentially means, do the thing. And there is, again, another complicated test to get through to try and, push the government to make a decision on something. But these are all of these things, whether it's a judicial review, mandamus, asking for a stay, they're all elements that you folks would really benefit from legal advice on. And what I'm saying right now is just legal information. It's all stuff that you could kind of find online on the court's websites or on websites about administrative law. But to know, what's realistic, what could be helpful. That's all stuff that would be best dealt with in speaking to legal counsel you might have access to. Unfortunately, in Canada, legal aid is not particularly available for this kind of thing. And so there can be, some quite serious challenges in terms of access to justice, which is why kind of systemic efforts like those that the Caring Society and others lead are really important to trying to move the conversation forward. I don't want to take up more time with lawyer stuff. So I'll leave it there and keep my eye on the questions in the chat. Thanks very much for attention, folks.
Thanks very much, David, for that wonderful oversight of avenues available to families via appeals mechanism, via federal court, be it through judicial review or mandamus. In the chat, you will have seen I posted an information sheet that outlines various avenues available to pursue should Jordan's principal request be denied or delayed. So you can check that out. But without further ado, I want to introduce Naiomi Metallic, who is our next panelist. And Naiomi is from the Listowitch Mi'kmaq First Nation in Quebec. She was the first Mi'kmaq person to be a law clerk at the Supreme Court of Canada. And as of right now, she splits her time between law practice and full-time faculty at the School of Law at Dalhousie University. And she is a legal scholar who is very interested in writing about how law can be harnessed to promote the well-being of Indigenous peoples in Canada. And today we've asked her to come on board and chat about accountability. So thank you very much, Naiomi.
Very welcome. I'm sharing my screen. I hope that works. Wel dasi begisin giskuk gwe nindeluizi Naiomi metallic outleawi listigoch. Just a little introduction of myself and my language. What I'm going to talk about in the little time that I have is it doesn't exist yet, but it's something that we feel very strongly. I wrote this report with some other people about what needs to be in place, and it sort of picks up where David sort of stopped, which is sort of describing the legal mechanisms and that there are limitations in some of the legal mechanisms that exist. A few years ago, Cindy and ISK at the time approached myself, and I approached a couple of other people to assist me to write a report about how we can do better for Indigenous children and families with regard to creating an accountability mechanism, better accountability mechanisms on Jordan's Principle. So I want to just touch on a few key points with respect to what we wrote, because I think it's still important and there's still opportunities to do this. Like it hasn't passed us by. Of course, the government could do this anytime, but also in the conversations that are still going on around long-term reform. There is opportunity. There had been in the proposed previous settlement agreement or framework agreement. There had been discussions of these types of like dispute resolution mechanisms. So I'm talking about stuff like that, but what I'm trying to say is that this is not out of reach. These are things that Canada can and should do. So I'm just going to jump over some of the quotes in the interest of time, but the bottom quote here is from the tribunal, recognizing that this was one of the worst cases of discrimination in Canada's history, right? So it's a serious issue and ongoing serious issues that we are dealing with. So what we got asked to do was to look at what were potentially other mechanisms alongside the existing mechanisms that are there today. The Human Rights Commission was already spoken about, and the tribunal, going to court, federal court. So what we were looking at were mechanisms that exist in other places, like ombuds functions, child advocates, and such. And, some of these things, in fact, exist in the provinces with respect to child welfare services. And in some federal departments with respect to some federal programs, for example, Veterans Affairs, there are things like ombudsmen, but yet none of these really exist with respect to the services that ISK provides to Indigenous children and families. So the idea was to take a look at this. So what we had committed to do was to write a report setting out 3 potential options for an effective national Jordan's Principle ombuds-like function. And we use that concept of ombudsman broadly to look at all the various sort of models that kind of exist between internal mechanisms and going to court that can assist in resolving disputes. Moving on from that. Some of the things that these kinds of mechanisms do is they're designed to provide citizens with accessible, impartial, and informal and not cost-effective avenues for addressing disputes and problems. They can often have, they aim to resolve disputes. Sometimes they can have coercive remedial powers. Tribunals, for example, like the Canadian Human Rights Tribunal has powers to, like courts, to issue remedies that the government must follow. So we looked at that there's a whole sort of spectrum of what different bodies can have, and they can play a variety of important roles, such as handling complaints, systemic and individual, doing investigations. They can also make recommendations to government, emphasizing the need to undertake reform within programming. And sometimes they can go to the level of even, issuing binding decisions. So there's a whole sort of range of potential options. Just, that's a real quick sort of overview of some of the things that these bodies can do. In our report, what we do first to really get a sense of like what is needed is we sort of set out the whole context of what's been happening, pretty much since residential schools and beyond. And then after that, 1951, the section in the Indian Act that provided for, the application of provincial laws, which led to child welfare laws applying, which then, led to things like the 60s scoop. So we wanted to sort of take a look at all the things that, were happening to identify what it is needed to happen. And many of you on this call know what those things are. Overrepresentation of our children in the child welfare system, for decades. Interjurisdictional neglect, which is basically another word for, I think Cindy mentioned it earlier, but there's back and forth and the buck passing. I call it the jurisdictional hot potato because they're sort of playing a game and sort of the federal government and the provincial government saying, I'm not responsible, no, you are responsible, back and forth. And we've got, several, the Caring Society cases, findings. We know that, child welfare services, as well as essentially all other essential services provided to First Nations children and families on reserve, are chronically underfunded and underserviced. We also wanted to, we brought into this context the issue of all the non-compliance orders, which are ongoing. One thing that we really did touch on, and I think it's important when talking about Jordan's principle and the court's rulings about it, it was the finding it a legal principle and the things that have been said about it, it's because of all the inequities and all the other services that First Nations people have, and also often lack of, or provinces denying the availability of services. So it's all these gaps and all these different services which sort of accumulate in such a way that, so much is not available. Jordan's principle was identified as a really important stopgap to ensure that, those needs were going to be addressed as soon as possible. But that doesn't alleviate the need to address the underlying problems, which the underlying problems are that these programs and services are desperately underserviced and underfunded. And if you're not fixing them, and not gathering information to fix them, you are perpetuating the problems. And it seemed to us that that's, a lot of how ISK was moving forward, even with addressing some of the claims for Jordan's principle. It wasn't addressing the underlying inequities in existing services. That is really a major thing. And I think one big part of that, which I think is contributing, and this is just my hot take on this, but contributing to the problems or the sort of pushback or backlash today, is that there hasn't been information gathered, data gathered on all the different types of requests under Jordan's principle over the years that signify and that show us very clearly where the gaps are. To us, that was it continues to be for me a major area of concern, and something that needs to be addressed by greater oversight. We also raised issues of, statutory reform like Bill C-92, and that there was, with its rollout, there's still issues of some provinces perhaps being not following it, some lawyers not recognizing it, or courts. And so there needed to be, we thought, greater sort of attention to some of those statutory reforms that have happened. That is something that a tribunal could do. And so there's ongoing gaps both in education, advocacy, and accountability for sure. David was sort of touching already on some of those gaps. So what we had suggested in our report was we need something that's actually going to address not just one little piece of the puzzle, but a broader piece of the puzzle. So we felt that the accountability mechanisms that should be in place should address the whole suite of what we saw as the problems that are going on here, right? That includes oversight of Jordan's principle and how process or program that ISK is sort of running. But it's also oversight of ISK long-term reform of the Child and Family Services program, and its funding, as well as, funding and negotiation that is also happening with C92, because that's all related. We also felt that there needed to be more oversight over Canada's efforts at addressing systemic inequality in all services that relate to Indigenous children and families, because it's not just CFS, it's social assistance, it's disability services, it's education services, it's health services. So there's a whole variety of services that are implicated that need to also be part of solving the problem, right? That's what we mean by like systemic overview of these things. And I guess another part of it too that we felt strongly about is like there's a role for the provinces here. The court cases recognize that provinces have obligations here as well. And, provinces sometimes just sort of shove off their duties. And again, we go back to the hot potato issue of one government saying it's another government's obligations. And it sounds like that's what we're hearing a lot of from the federal government these days as well. And so, there actually has to be cooperation between these two levels of government. And that's what Jordan's principle is about, them cooperating and making sure that in that cooperation and figuring out who's going to pay for what, that children and families aren't harmed. So we felt that there actually needs to be questions asked of federal and provincial governments about what they're doing to talk with each other to ensure that there is no gaps and people don't fall between the cracks. And I don't really think that's even happening. Also, we thought that there needed to be greater education to ISK and to CERNA and provincial Department of Child Services, staff, lawyers who are working in this area. So many actors in the justice system really need far better education in this area. So we saw that as being a potential area of focus as well. We also thought that their role should include investigating and mediating and being part of complaints, individual complaints, both with respect to the federal government and the provincial government, and taking a role in mediating that. So we kind of felt like lots of times, because of the division of powers between the federal and provincial governments, things are so siloed. So if you want to bring a judicial review against the provincial government, you can't go to the federal court. You got to go to another court. If you want to bring a human rights complaint, you got to go to their Nova Scotia Human Rights Commission. It's very, very complicated and very difficult to navigate for the average person. And so the feeling is that this should be a one-stop shop where so many of the complaints involving children and families should be addressed in the same place, or at least they could play a primary role as a navigator here. So that would be really significant. With some of these bodies too, we felt that, part of it should be trying to mediate and resolve things, but we also need a body that has some teeth with power to enforce things in the way that the tribunal had. And so we can't lose sight of that. So we need also a body who can do some of that. And I guess the last point comes back to David's presentation, but legal advocacy for families and children involved in these processes. These are extremely complicated processes, and the average person cannot navigate this on their own. And so, the Caring Society and their wonderful team of lawyers, like David and others, have been helping out. But, often pro bono and with, on a shoestring. And so there needs to actually be something somewhat akin to legal aid to support people going through this process. So ultimately, those were basically where we went in our recommendations. I'll just say one more thing before I get into those recommendations real quick, is that we emphasized a few more things in the report. Whatever the solution looks like, it has to be external to ISK. It has to be independent, arm's length, external to ISK. And that's common. That's not uncommon. There are ombuds bodies that are external. You know, everyone, you know, that you need to have that in order for there to be real accountability. There are certainly internal mechanisms that ISK can undertake and that will improve circumstances, and we suggested some in our report, but that doesn't remove the need for there to be an external accountability mechanism of an ombudsman like nature that is independent. Also, we felt it should be set out in legislation, right? Not just simply created by government policy, because that gives it more strength and teeth, and people know what their mandate is, and people can enforce that mandate. I won't touch on the other points, but those are two really big ones. So what we ultimately proposed, and, you know, they had asked us when we started writing the report, write something that, you know, three potential mechanisms. And maybe they thought they were asking us to come back with something that was like three separate or different. Sorry, I'm just moving this over. But we felt that, in fact, the three that we put together are interlocking. And we felt that these had to all be interlocking and put together because of the stakes, right? Because of the long history of intransigence by Canada and also provinces in this area. And so we said the stakes are too high, the patterns of discrimination too long and entrenched, and Canada's practice, policy, and even legal reforms still too inadequate for anything less to be effective at this point. So what we had put forward was a national Indigenous child and family advocate, then which would be supported, and then if, you know, would be the one to sort of mediate the disputes and would be the sort of first point of contact and would potentially navigate and support and try to address disputes in cooperation with ISK, but arm's length from it. But if that didn't work, there would be a possibility to send it up to something like a National Indigenous Child and Family Tribunal. Which would have some role that to some extent looks like what the Canadian Human Rights Tribunal does in terms of the remedies it's able to order and such. However, we did feel that a separate, specific, designated tribunal is really what is needed here. Some of this, you know, like all of this is sort of happening now at the tribunal level, but it would be great at the Canadian Human Rights Tribunal, but it would be great to have this separate tribunal. And then to support both 1 and 2 are national legal services for Indigenous children and families. So I'll just say a couple more things. I know I've got maybe a minute or two left. So we had based what we proposed at looking at sort of different ombuds models, including the child advocate model. And the child advocate model sometimes is a bit more focused on the needs of children informed, and some of its staff can sometimes have a role perhaps in ensuring that the child's needs are placed front and center in the best interest of the child. And so we were sort of basing that, and many provinces have child advocates. Alberta does, British Columbia does. My jurisdiction right now, Nova Scotia, does not. And that's something that is really lacking. So, but we felt that sort of emphasis would be really important. And we felt that they should have broad jurisdiction to oversee both the federal and provincial, well, primarily the federal, but also a link to providing oversight and navigating along with the provinces or alongside provincial mechanisms. But we wanted it to have specific jurisdiction to oversee both government's delivery of services to Indigenous children and families in accordance with Jordan's Principle, substantive equality, and UNDRIP and other relevant, international and human rights instruments. So to be able to address individual concerns, but again, providing that systemic oversight, which is, in my view, quite lacking. So that would be really important. And then again, trying to assist Indigenous children and families to resolve their individual complaints through informal and confidential means. So that's sort of the first step, trying to address them in an informal way, working with ISK. But then if that did not work, you needed that next step up, which would be a body that is separate from the child advocate, but has the ability to hear complaints and adjudicate them and make decisions and make legal orders that are binding. So we think that, again, their power should be fairly broad and include also systemic complaints. And what's really important is that this tribunal should have robust remedial powers to uphold substantive equality and other statutory human rights of Indigenous children and families. And again, we did want it to be one where potentially even complaints against provinces could be brought, because again, as I say, right now you have to go to 2 different courts. If you wanted to sue, if Canada and the province were fighting over something and they both said they didn't have to do it, you would have to bring the federal government to one human rights body and the province to another, or to one court or another, and that's not access to justice. There's not very effective access to justice. So we wanted this to be, again, another kind of one-stop shop specifically on this issue. Yeah, and then the final thing is that we wanted, again, paid legal services or support for families in going through this, because it is extremely expensive and complicated to do this. And there are existing models for that. The Alberta Child and Youth Advocate has a branch that is about giving legal representation to children in care and who need supports. And so it's a model that already exists and seems to be fairly effective. So that's my time. I'm going to leave it there. Thank you very much.
Thank you so much, Naiomi. And thank you so much to all the panelists. This now concludes our panelist portion of the webinar, and I'm going to invite the panelists to turn on their cameras when they're ready, and we're going to answer some questions. I've done my best to sort of organize some of these questions that we received through the Q&A chat by themes. So I may not ask your exact question, but I'm hoping that I've asked sort of the question thematically. So the first one that we're getting a lot of is our question about substantive equality and how ISK is using substantive equality to deny requests. For example, using Section 15 under the Charter as a denial rationale. What does this mean, and how can it be addressed? Maybe David and then Naiomi can also try to answer as well.
Sure. So I can kind of answer 2 permutations that I've seen of this. One is there's been a statement made that, Section 15 and Section 5, so Section 15 of the Charter, that's the part of the Constitution that guarantees equality rights, and then Section 5 of the Canadian Human Rights Act, which is one of the sections that set out, kind of what discriminatory practices are. 5 has to do with services, that they require essentially an existing service in order for there to be some application of substantive equality. And the pushback on that is, kind of part of the case that's before the federal court right now, is that the Human Rights Tribunal orders actually deal with this pretty specifically in 2017, and then again in 2020, and then again in 2025. And essentially what they say in those orders is that when you look at substantive equality, part of the problem sometimes can be that nobody's providing the service. And so it's not just limited to existing government services, that you have to look beyond those services where there are unmet needs that are tied back to the First Nation child status, as a First Nations child, as well as intersecting grounds of disadvantage they may be facing, because some kids have other forms of disadvantage that are protected, such as disability, under both Human Rights Code or Human Rights Act, and the Charter. The second version that I've seen of this has been where there is an existing program, for instance, having to do with special education, or having to do with housing condition on reserve, and they point at those programs and say that they're ameliorative programs, meaning that they're programs that are targeted already to disadvantage, as opposed to a generalized program, and that because of that they're protected from review under the Charter or the Human Rights Act. And there is a Supreme Court of Canada case from 2018 saying that that's actually not how those protections work. Those protections are there so that folks like me, unquestionable member of the majority can't come and say, hey, I'm being discriminated against because there's a program here that's, meant to ameliorate the condition of those who are less well off, and that it would kind of turn the provision on its head to say that the folks who are supposed to be protected or helped by those ameliorative programs can't challenge them for not actually meeting, the requirements of the Charter or of the Human Rights Act. And so that's another argument that we're waiting, for guidance on from the federal court. And I mean, on the second argument, the tribunal hasn't ruled on that, but on the first one, it seems to me that the guidance is already clear, and so it's unclear to me why that's not being followed by ISC at this point. Naiomi, I don't know if you had anything to add to that.
I mean, it's all correct. I can only just emphasize, and maybe I'll just be a little bit more flippant about it. Like, I do feel that the definition of substantive equality is well established. There's been several Supreme Court of Canada cases talking about what that is. I have a whole paper talking about how, especially how the tribunal used it, was really like just incorporating what the court had said, but really applying it in the Indigenous context. And it's paragraph 465 of the 2016 decision, the main decision, where they say substantive equality is about recognizing the needs of Indigenous peoples, which include their historical, cultural, and geographical needs. And so, I really, and of course, and like the requiring that there be an identical service is the definition of formal equality. That is it. You have to find a one-to-one comparator or a one-to-one program, and if that's not there, the court has said that is formal equality. We embrace more than that. We embrace substantive equality, which means that you might have access to different services if your needs are different, and Indigenous peoples have different needs because of our histories and traditions, the whole history of colonialism, and so many other things, right? So, I just honestly have to say that, I would be just shocked if a court didn't say, like, that definition that ISC is trying to float isn't bonkers, right? Like, they probably won't use that terminology, but that's what I feel about it. And also this argument around social, ameliorative services. I mean, if you take that approach, then any time the government offers or has legislative obligation or has services that they provide services that are helpful, that are social services, then what they're completely immune from charter scrutiny and human rights scrutiny makes no sense. The court said as much in a case from 2000. I don't know. I forget what year Eldridge is from. You can correct me, David. But and I agree with David that
1997.
Thank you. He's so good. But I also think that, he's right when saying, where 15.2 or where this idea of ameliorative programs applies is cases of reverse discrimination, right? And the case that comes from is CAP, where it was non-Indigenous fishermen challenging a fishing program for BC First Nations on the Fraser River. And the court said, that program is protected from attack by these non-Indigenous fishermen who are saying, oh, it's violating my equality that I don't have access to this. That's the example of the types of service that's when that argument applies. It doesn't apply when the government is underfunding you or underservicing you in services that you are entitled to as a citizen of Canada. So, I agree with David, in other words.
Thanks both. And Cindy, did you want to add anything?
Yeah, the one thing I would say is troubling is that we've already litigated this against Canada in the main case. One of their key things was that it had to be services available to everybody else. The comparator argument, as we called it back then. And David will correct me if I get any of this wrong, but that was well ventilated before the tribunal in the original decision and rejected by the tribunal. And I sometimes worry that there's been so many staffing changes over at the department that they forget the history, the origin story of Jordan's Principle, and that these issues have already been raised before the courts, they've been aired before the courts, and the courts have made their decisions. And I want to also just mention that there are decisions on Jordan's Principle, the one that David has been referencing, where they've appealed, Canada has appealed Jordan's Principle decisions to the federal court, and they have lost. One of those is this idea that First Nations children recognized by their nation, regardless of Indian Act status, and I just want to say clearly my own view, and I think the view of many others, that's a piece of racist legislation, that children recognized by their nation on or off reserve are eligible for Jordan's Principle. And they appealed that decision in federal court, and they lost that decision in federal court, and they chose not to appeal it further. But we're seeing hints of policy decisions, for example, on their website that Jess so eloquently took you to, where there's these subject to substantive equality, you can't get educational supports off reserve. Well, first of all, I think if they're applying a test of substantive equality, that ought to be accountable and transparent as to what the standard is, what the process is, who's making those decisions, what are their credentials, and what elements of substantive equality do you meet or not meet? Because substantive equality's got a basket of things that Naiomi's pointing to that they have to take into account. It's unclear to me on the face, on many of the cases we're seeing for children, that there's been any credible application of substantive equality reviews for children on the cases. And I think that this is one of the areas of frustration that certainly we have that demands the type of oversight that Naiomi was pointing to.
Thanks all. So a lot of questions about the operational bulletin, and as Cindy pointed out, a lot of this rollback of ISK's implementation of Jordan's Principle is linked to this operational bulletin. As a note, the Caring Society has asked for ISK to withdraw the bulletin. We have not received a substantive response yet from the department on that, but we certainly welcome that response publicly. And we do view the bulletin as a significant departure from the tribunal orders. And Cindy, I would invite you to, if you wanted to add anything on the operational bulletin.
Well, I would say that we've seen zero evidence that experts were consulted in the development of that bulletin, that the legal orders were carefully reviewed to ensure there was no intentional or unintentional breaches of the existing orders. We have not seen any evidence that First Nations were consulted or that there are many experts who are working on the ground. And I just want to give a big shout out to these people, because whether you're working directly with families, you're seeing firsthand the broken hearts and children and their families who are not able to access these services. And you have played a key role in making sure that Jordan's Principle has gotten out there. So I just want to recognize each of you in doing that. You weren't consulted in this either. The department, I don't know what process it used to generate this thing, but it just unilaterally went out there and applied it. And even when First Nations and experts on the ground and others raised the alarm about the consequences that this bulletin is having for children in real time, in very devastating ways, the department has not been willing to change course. That to me is a marker of the old mindset that the tribunal has identified in the department time and time again in this case. This unwillingness to do better when they know better. And if the federal government wants to demonstrate to everyone that it is going to follow its own laws, that it is going to ensure that it does not harm another generation of First Nations children now or any time into the future, and that it can be trusted to implement the legal orders so that the discrimination does not recur, then it needs to learn from its past mistakes and its ongoing mistakes and recalibrate. So I think this bulletin was a serious misjudgment, and it should be pulled back with expediency. And I would say any family that was harmed by this or child that was harmed by this should have the availability of a swift review and a remedy.
Thanks, Cindy. We've had a lot of questions in the chat about the National Review Committee. Jess, I'm wondering if you can walk us through what is the National Review Committee, who's on it, and why or which cases or requests escalated to the National Review Committee?
Yeah, so another a frustrating thing that I'm sure most people have seen is that the request may have been escalated to the National Review Committee. So in essence, this means that the National Review Committee has a little bit more discretion in terms of approving requests. So in the past, we've seen that certain dollar amounts for requests cannot be approved at the regional level and have been escalated to national, or in some cases, previously, if a request might be denied, it's escalated to national to receive that determination. However, in the recent months, we've seen that all requests or most requests are being escalated to the National Review Committee, and I don't think we've ever received confirmation on why, but across the board, it really doesn't matter what type of request, whether it's approved or denied, the dollar amount, we're seeing an influx of cases and requests being sent to the National Review Committee for determination, which also is a bit confusing in terms of how they're going to eliminate a backlog when they are circumventing this broad amount of requests from all regions to this National Review Committee. So it is beyond us how this is going to solve the backlog or eliminate any further delays, but essentially they are going to this committee who in the past we have known to have a little bit more discretion in terms of approving or denying requests. And I don't know if Brittany, if you have anything else that you wanted to add.
No, that's great. Thank you so much, Jess. Yes, we are seeing a tremendous amount of requests being escalated to the National Review Committee, also sometimes called headquarters. And initially this was set up because there's only actually a few people within the Indigenous Services department that can deny requests. So for the most part, requests are escalated to HQ when either they're outside of the authority within the region or it's being recommended for denial. Most importantly, the tribunal ordered timelines still apply whether or not the request is noodling around in regions or noodling around at headquarters. It still applies no matter where it is. So we've also had a lot of questions about the appeals committee. Do we know who makes up the secretariat, David? Has that information ever been publicly disclosed? And is there a directive to address the backlog at the appeals committee?
Yes, so there's kind of two components to the appeal process. One is the appeal secretariat, which is public servants, inside ISK who are, organizing and assembling the materials. And so what we see in, for instance, a certified tribunal record that you get when you go to federal court is that there's a package that's put together for the review committee. And so that's the appeal secretariat who kind of handles that piece of it. I haven't ever seen a way to get in touch directly with them. It's always been through, ISK regional office, folks that then transmit stuff on to the secretariat. In terms of the decision makers, as I noted a bit earlier, our understanding through the Jordan's Principal Operations Committee is that there are 6 of them right now. The exact membership of kind of who those 6 folks are isn't something I'm up on at the moment, but my understanding is that they're, I think, a few dentists and who may or may not be affiliated with the appeal process through the non-insured health benefits. That's speculation on my part. I know that the dentistry component or orthodontic component of the NIHB has its own internal appeal mechanism, and so again, just speculation from my part. And I believe there's one pediatrician. Over time, I've seen things like folks with special education background. I think I might have seen a physio at one point, but the membership isn't something that is unchanging. In terms of addressing the backlog at the appeals level, there's no specific directive around that. There's not a specific time frame that the tribunal has ordered for appeals. The tribunal did talk about the need for an independent process in its last decision and how important that was, but didn't, frankly, didn't have evidence before it of any backlog at the appeals stage then, because there wasn't. But the way that backlogs work, it makes sense that the backlog is moving through the system, at least logical sense. So personally, I have cases that have been at the appeal committee for 6 months and still no answer. I have had one experience of an appeal decision being made more quickly where there was something pending in front of federal court. It was quite an urgent situation, and so there wasn't time to wait for the appeal committee to make a decision before going to federal court, and that essentially the appeal process caught up with the federal court process in that one situation. But there have been other situations where there was a federal court process underway and the appeal decision didn't come until quite further along in that process. So I would say there's not really much assurance, at least from where I sit, of an appeal that goes in today being decided in a particular time. But of course, and this isn't legal advice, it's just common sense. If there's something in your situation that's particularly compelling or important, it's pretty important to say that very directly, including like in the covering email that's sending the appeal in, so that the system at least has the chance to understand that there's something that's particularly urgent. But if you are facing urgent circumstances, that's a good time to go and go to your usual places. You get advice about what to do with Jordan's principle.
Go ahead, Cindy.
Brittany and David, if I can just jump in here, just one quick thing. One of the things that I think many people are worried about is this appeals process is so inaccessible that it actually doesn't serve the need of an appeal for the child. Is there any law that you can describe out there when governments create something that you're supposed to exhaust first, but that process is so ineffective that you just need to move more quickly to another remedy?
So when there are appeal processes like the one that has been set up for Jordan's principle, that is essentially a step that has to be gone through before the federal court will consider a case. And this is called the adequate alternative remedies doctrine. It's a kind of a legal phrase that means like actually you have another way of solving this problem that's not coming to court. So please use that way, because if it works, then the court can, use its scarce resources on other cases rather than dealing with a case that could have been dealt with elsewhere. But there is case law out there that says where the thing that is supposed to be the adequate alternative remedy actually isn't adequate, in that it won't address the need that is leading to the appeal, or won't really provide a remedy that would be meaningful. That could be a circumstance in which one could go to court. I think the expectation that anyone could the expectation anyone should have going to court making that argument is that the Department of Justice would resist it. And so it would be important to talk to any lawyer you're working with about just being conscious of that and how to bring evidence to show the particular urgent situation. But there is an exception to that doctrine, which is where the evidence shows that it's not actually going to be adequate in resolving the case.
Thanks, David. Cindy, did you want to add anything? No? Okay. So another question that we're seeing a lot of is, and I'll open this maybe to everybody who wants to chip in on it. Can ISC deny very specific product services support? So for example, can we see them say, nope, we're never going to approve off-reserve education supports. We're never going to approve certain therapies that are recognized by a licensing body as a good treatment for children, and that are recommended by a licensing professional for a specific child. Can ISC do that? Is there anything in the tribunal order saying yes, no, maybe so? Cindy, do you want to take first crack?
I'll say what I've seen as a troubling trend is taking broad categories of services and saying never, or subjecting it to a very obscure test of substantive equality where there's no evidence of what the standard is or what the process is or the decision makers, like I was talking about earlier. That, in my view, is not permitted under the tribunal's orders. The tribunal's orders are to remedy the discrimination at the level of that child, giving in context their distinct circumstances, or in the cases of a group request, a group of children. So you can never say that service X will never be needed by any child. That's not a credible application of Jordan's principle. Because we had, for example, in evidence by the federal government as part of our most recent non-compliance motion, evidence by them saying things like a list of items that are, in their view, spurious, like glow sticks. Well, glow sticks are actually used by children who are neurodiverse as a calming mechanism. So, you know, something at first brush that might look like it's not needed, actually, it can be needed in specific circumstances. And this is why we're really relying on experts in the area, people on the front lines who have eyes and ears on that child, and the professional expertise, or in the case of elders and knowledge keepers, their expertise or sacred expertise, to be able to say, this is the child, this is what they need, and federal government, you need to be funded under Jordan's principle. It's that simple. The Fed should not be in the business of making case decisions. And I'm worried that that's really what this is amounting to. And the tribunal cautioned against that in the 2016 CHRT2 decision, is that funding decisions can become case decisions that really impact the safety and well-being of children. And I fear that's what's happening now.
Thank you, Cindy. Naiomi, I have a question for you. So we have seen years and years of and ruling after ruling trying to get Canada to adhere to the tribunal orders we've issued. We've brought Canada to the tribunal many times. So what happens next, right? How can the government be held accountable and be brought into compliance? What are some legal options available? It's a doozy.
It is a tricky one, and I get the frustration that underlies it implicitly. Like I get it, I understand. I'm faced with that same frustration as well. I mean, there are things that have been working. I mean, if you were to like go back, and I was reflecting the other day on the impact that the Caring Society case has had on so many things. And yes, there's still frustration, and yes, and there's so much non-compliance, and almost a real backtracking, it feels like. But we have made gains, and it all just doesn't lie with the federal government or the executive, right? And we have to remember that there are other players at stake. There are the courts. That can sometimes be quite frustrating, but you know, but there's a tribunal as well, and we've gotten wins there, you know, significant wins. We moved things with legislation, right? C92, not perfect, I agree, but certainly things to work with there. So that's another mechanism of, you know, people pressuring their elected officials to do things. Like, so we can push and move Canada to act, maybe act to pass a law about a tribunal and an ombuds, right, in this area. So there's that way that you can push. And so, you know, and, you know, there's also, you know, raising things in the public, raising things at international levels. There's a lot in the toolbox, but I get that there can be frustration when it just like, it never really seems to end. And I don't know if there's a real, like, so we just keep fighting because the kids are worth it. Our people are worth it. And we have more, I think, allies than we've, you know, had, you know, at other points in history in terms of the courts and politicians and stuff. So we keep working those. And you know, Cindy, you probably say it better than I can, but like, I do feel that's, you got a big toolbox, and you just got to keep trying to work those different pieces and move some of these impossible things to move, or things that roll backwards even.
Thanks, Naiomi. Cindy and David, about this big doozy of a question, is what sort of tools are in the toolbox, as Naiomi said, to hold the government accountable? So Naiomi raised writing to politicians, which I think is an excellent one on the Caring Society website. We have a list of who to contact. I'll pop that in the chat shortly. But David and David and Cindy, anything to add?
Cindy, you go ahead. You're the advocate par excellence.
Well, what I would say is that documentation is key. Document everything. If you're told something verbally by the department, send a letter back and document it and confirm that that's their position, and get them a time frame to confirm it. I found that documentation is really key. And one of the things that I felt a real personal responsibility to do here at the Caring Society, and our whole team feels this way, is when we see a problem, we actually work with experts, and that means people on the ground, but also people in universities, and often across different disciplines, to come up with remedies. So not just to be a backseat driver saying that this doesn't work on a systemic level, but really to put forward these evidence-based solutions that could address the problem. And so if you're in that position, great. If you're dealing with an individual child who needs help right now, I agree there are a variety of ways. This is a new government, and I would frankly not stop at writing to the bureaucrats. I would copy right up the line. This is, they are all accountable. The deputy minister, the minister, the prime minister, copy that letter up and down the line so that people know what is happening. Look at the media. I just want to put out special shout out to APTN that covered our case right from the beginning, gavel to gavel, over the 72 days of trial. And incredible documentary filmmakers like Elenisa Bomswin and others who are out there telling these stories. The other pieces are to turn to your legal clinics, your First Nations leadership, to other allies that are in the health, education, and social services sectors, and give them something to do to be able to support the full implementation of these legal orders and take legal action. You on the front lines are seeing what the implications of Canada's decision-making on children in real time. You are in the best position to bring evidence to the court, to the federal court, or to another fora, to show that the discrimination is happening because of choices the federal government is making. And certainly, if there's ways we can be technically helpful in that process, we're willing to do so. But I agree, you never give up on the kids. You can just keep on pushing, but try to do it in a way that is actually about trying to solve the problems.
Thanks very much. And I just noticed that we're 2:35 Eastern Standard Time. We're wrapping up at 2:30, so we're 5 minutes over, and I think we will wrap it up there. I really want to thank everybody for popping their questions into the Q&A. I know we did not get a chance to address all of them, but I do hope that between the key questions to the panelists, the questions and posts that we posted in the chat, and also addressing the Q&A, we've addressed most of these questions. And this webinar will be available on the Caring Studies page and YouTube page in the coming days. So keep an eye out for that. We'll share that on our social media accounts as soon as it is available. And on that note, I really wanted to thank our amazing panelists, Jess Raby, Cindy Blackstock, David Taylor, Naiomi Metallic, as well as our amazing colleagues, Melissa and Stephanie, for lifting up the back end and answering those questions and coordinating so excellently. I wish you all a wonderful afternoon. And Miigwech, hi, thank you.